The question on the screen is the one we're going to talk about tonight. And I'm going to start out with the one single example we have of a president who was charged and convicted in a criminal case. General Ulysses S. Grant was charged with speeding. Now this was 1870, and you can think about how he could have been arrested for speeding, but he was a guy who loved to ride horses as fast as he could make them go. And he was stopped one day by a constabulary, a policeman, somebody in Washington, D.C., and was told, "You can't do that, and I'll give you a warning." And so Grant the next day came back and did it again, and the policeman was there, and they went to the courthouse, and he paid a fine. So if anybody says there's never been a president convicted of a criminal offense, you can say, "Oh, no, you remember old General Grant." Well, now the fact is the historians are not totally sure that's true, but there are records of that sort around, and it's used a lot. But don't bet your life on it, because it may be just a rumor or a story. But the fact is, it's very rare in the United States for a president to be indicted and charged with a criminal offense. And that's why this case has arisen. Now, just a word of preparation here. Usually when in these annual talks I give about the court, I mention 2 or 3 cases, 3 or 4 cases, maybe more. This time we're just going to talk about one case. It's not the only case they decided, and it's not the only important case, but it's a case that seems to me to be as far-reaching as any single term has produced in a long time, because according to the dissent, the 3 justices in dissent in this case, this is the end of democracy if you permit the president to be above the law. And so I think it's a very important case. Now, we've had presidents before who've had some criminal possibilities. I think President Clinton was involved in the criminal stuff about some testimony he gave in the Lewinsky case, but that they settled. He worked out some kind of a deal, and as only he could, and so that case was never tried. Richard Nixon was also involved in some stuff, you may remember, and he decided not to wait for the court to open. He just resigned. So we don't have that case before us either. We don't have any Supreme Court opinions, and General Grant never took his case to the Supreme Court. So we don't have any Supreme Court opinions on the question of whether a president is immune from criminal prosecution. But I thought, since we now have some law on the matter, or at least according to 6 justices of the court, it's worth a little talk. Now let's see if I can figure out. Look at that. So there's the situation we're going to talk about. Oh, it is, eh? All right. This technology I've never gotten used to. You know, I'm still a blackboard guy, but nobody has a blackboard anymore. And even if they have them, they're not even black. So what can you say? We're going to talk about this case in a couple of ways, and this may be a little unusual because you're going to get a diagram up on the screen that covers the whole screen, boxes and arrows and stuff. As I'm trying to work my way through the Roberts opinion in this case, it seems to me, trying to figure out exactly what he said, what you're going to see is a diagram of my view of what he said. I've shared this diagram with some experts around the country, and they all say, well, I would have done it a little differently, but it seems accurate to me. So it's going to be a little different kind of a presentation on the screen. You're not going to get any photographs, any drawings, unfortunately, no music. But it'll be, I hope, an opportunity to look at the opinion that Roberts wrote and see what it involves and what it decided and what it didn't decide, because it's, I think, a case we'll be spending a lot of time with. So we'll look at that, and then I'll give you my evaluation of it when we get it up on the screen and tell you what I think about it, and then we'll have some time for questions. I'll mention some of the critics briefly and the dissenting opinion briefly, but mostly what I'd like to hear what your questions are. Okay, we're talking about immunity. And if you put immunity into Google or one of those things now, you hear a lot about various kind of diseases and various kind of bugs and various kind of medications. We're not talking about that kind of immunity. We're talking about immunity from prosecution. And when a party is proceeded against in a criminal case, the claim of immunity has to be resolved first. You don't have the trial and then see if there's anything that stops the trial. If the person is immune from that particular set of laws, there's no trial. The matter is subject to dismissal at the outset. So, and that's where we are with this particular case about President Trump. There's been no trial. There's been no elaborate discussion of stuff. It's all handled on the pleadings, a motion to dismiss, which was not granted by the district court and was not granted either by the Court of Appeals in D.C., but was reversed by the Supreme Court. So there's yet been no trial in the case. So we're talking about strictly legal questions. Why do we worry about immunity? Why should any official be immune from laws that apply to the rest of us? Well, you kind of get used to the idea. First of all, if you think about the Middle Ages, the king in England was above everything. And so the law could not apply to the king. He was a sacred person, and the law simply couldn't apply. But we had a revolution, as I recall, turning on that very principle. We didn't want somebody who was above the law. So when the framers sat around to draft our Constitution and set up the structure, they had to have some kind of a chief executive to run the store. And so what are they going to call him and what powers are he going to have? And some people said, well, he ought to be called Your Excellency or something like that. And the framers said, no, we want a non-regal, non-religious title. We want something that is totally Republican in that sense. So he came up with the word president. And he is not a king, and he is not a dictator, and so on, we hope. Guess I better change that sentence. Anyway, they wanted somebody who was not above the law. And all the conversation in the debates in framing the Constitution, all the discussion in the ratification debates, everybody was assured that the president was not the king. He was not above the law. He was subject to the same law everybody else is, including criminal law, including punishment. And so everybody was told, don't worry about, go ahead and ratify this Constitution. It's safe. It's okay because the president will not be above the law. Lots of conversations about that. But there still is a kind of immunity that's around a great deal. For any official, state, local, federal, we don't want to put them in jail whenever they do something that might violate some other law. If the fireman comes and chops an axe through your door so we can get in and put out the fire, that's a crime. Knocking down doors with axes. But we're not going to hold him liable. So we have a lot of patchwork in state and local laws of immunities from various laws, various levels of intensity of immunity, various levels of completeness of immunity, but they're all designed to make it possible for people to do jobs that they have to do in the public interest that might, but for the fact that they were acting under authority, would violate some law. So the policeman that arrests somebody is confining their freedom, and so on. That's against the law, but the policeman has a defense, and in some places that would be called a partial immunity, qualified immunity. So there's a lot of that around in the country, in the state and local level, and everybody's got used to the idea. We're kind of happy that the fireman doesn't have to stop and call his lawyer before he can chop your door down, and the policeman doesn't have to call his lawyer before he can stop a speeding horse, I guess. So that idea we're all comfortable with. And you could say, well, you don't need to call it immunity. You could just call it a defense, and that some places it is. But the word immunity gets into the literature. So in the state and local level and some other federal settings, the word immunity means this is an official who, in carrying out his or her duties, may violate some rule that you and I couldn't violate, but we're not going to hold him liable because of his office and the importance of his office being carried out. So immunity is around. The problem with the presidency is that the president is a very unusual office. And I'm not talking about individuals, I'm talking about the office now. When you read through the discussion of the framers, they made it very, very clear that they wanted a vigilant, energetic, innovative, unafraid, creative executive. And so they said, we don't want somebody who's sitting around wondering whether, well, if this seems the right thing to me to do, what happens if after I'm out of this office, my successor sues me or brings a criminal action against me? Well, I think A is the right thing to do, but B is safer from that standpoint. I'll do B. They didn't want that. They wanted a vigorous and independent executive who would not have to worry about what later successors what charges they might bring against him. So they had this sense that there should be some kind of immunity attaching to the office of the president. And the king's immunity was in the background, the local patchwork of immunities about local officials, all that's in the background. Everybody, all the framers knew all that. So that was what they were talking about. So Madison, who was a very important guy in the framing of this document, said, let's have a statement in there about the existence and extent of the presidential immunity from law. And for some reason, they didn't pick up on that. They ignored that argument of Madison's, and they ignored very few things that Madison said, but for some reason they ignored that. And one argument is they ignored it because they didn't want a statement in there about immunity. The king was not going to, this king was not going to be above the law. So they didn't want any discussion of any kind of immunity. Others say, no, they just forgot it. Others say they ignored Madison. I don't think they forgot very much, and I don't think they ignored Madison very much, but there it is. There is nothing in the Constitution about presidential immunity. Now, if you're an originalist and a textualist and all that other stuff, you say, well, if it's not in the Constitution, it doesn't exist. There can't be an immunity unless it's in the Constitution. And mostly the originalists and those people who interpret the Constitution literally would agree with that. Unfortunately, the 6 members of the court kind of ignored that principle and said, well, yeah, it's not in the text, but we think it should have been, so we're going to put it in anyway. That's a very unusual position for those justices to make, for this court to make, because they're usually very insistent on the literal language that the framers used. When they got to at the convention, they had, and this may have been why they didn't take Madison up on the suggestion, there's a kind of conflict. On the one hand, we want a vigorous executive who is not afraid of anything and do what he thinks is right, he or she thinks is right. On the other hand, we want the king not to be above the law. And those are kind of conflicting because the fear of prosecution might make the executive less energetic, less innovative, less forceful if he or she is worried about later liability. So those two things kind of conflict. And when things kind of conflict in a drafting convention, either something doesn't get mentioned at all because they can't agree on the words, or it's put in some sort of fuzzy language that nobody really understands, and the courts and the rest of us have to figure out later what they really meant by that. And I think in the case of immunity, it was just left out altogether, so it doesn't exist in the Constitution. So there we are, and along comes Donald J. Trump. Now, if ever there was a person who seems to have made his life mission to unsettle the Supreme Court doctrines, this is him. And so a federal grand jury indicted him for 4 different grounds, and they all had to do with interfering with the election process in some way or other. Now you may know there's also a case in New York, a state case involving records in the Stormy Daniels case, and there's a case in Georgia involving what he said to the state of Secretary of State in there, and there's another case in, where's the other one? It's in Florida. Yeah, Florida, the classified documents. These are all pending cases against Trump, and they're all in various stages of disarray and appeal and all that sort of stuff. The Georgia case, you remember the district attorney had some romantic relationship with one of the prosecuting attorneys, and that just got that thing messed up. And in the Florida case, there's a Trump appointed judge down there who dismissed that case because she said the special prosecutor, Jack Smith, was improperly appointed. So she dismissed the case. Well, that's on appeal too. So there are lots of things going on around. And Trump is, he must hire a whole room full of lawyers. And it's great for the law business. I mean, lawyers have to eat too, So in any event, the sort of things Trump is said to have done in this indictment, and you know them all. They've been in the headlines. Knowingly false claims of election fraud, promoting false statements, fraudulent electors to transmit false certificates, pressuring the Department of Justice to conduct sham investigations, pressuring the vice president to not certify these votes, and of course, inciting an angry crowd to storm the Capitol. So those are some of the things this allegation claims he did. Now, what laws did they violate? Well, a whole bunch. There are a whole set of federal regulations, and if you look into this case, you'll see them all cited, all these statutes that say you can't interfere with the election process, you can't obstruct the public business, you can't do this or that. And so all these statutes would make it a crime to do these things. And the special prosecutor here looked at the evidence and looked at the statutes and said, we think he did those things. So an indictment was gotten. And just to make you clear about the fact that these are significant crimes, 1,200 citizens were charged with violating these things out of the January 6th turmoil. 1,200 citizens. And these are all cases now in which the prosecutors were able to find pictures and evidence and witness testimony about each of them to show that they were there and they were doing these things in violation of the statute. So they were all, 1,200 of them were charged. Of that 1,200, 900 were convicted, which means the evidence was put on, the photographs were shown, the testimony was reviewed and examined and cross-examined, and a jury found them guilty. So we have very serious laws here. 900 have been convicted, and 500 of them got jail time for their efforts on the 6th. So it's a very serious set of laws that are being violated here, and those are the ones that Trump is charged with in these 5 particulars with doing. Okay, an indictment is filed, and that means now not that Jack Smith said, I think Trump's a bad guy, I'm gonna file a paper in the court and get him in trouble. That's not the way it works. An indictment requires, in all these cases, a grand jury. Well, first, the prosecutor has to develop the facts and study the law and conclude that the guy probably did this stuff and that they did probably violate the law. Then he presents it to a grand jury, 25 or so citizens who look at the evidence and look at the law and say, looks to us like there's probable cause here to go ahead. So this is not Jack Smith's private view. It's been run through that particular mill. And so he files, this indictment is issued, and what Trump does is move to dismiss. Now technically that means that we're not going to have a trial, we're not going to discuss whether or not the evidence is adequate or not. We're just going to see if there's some grounds that we should not even proceed any further with this, and he moved to dismiss on the grounds, not that he hadn't done any of these things, or not that these things didn't violate the laws, but he moved to dismiss on the grounds that he was not subject to those laws. He had immunity. And well, that just makes a very clean case. And so at that point, without a trial, without any elaborate discussion and arguments and briefs and all the rest of that stuff, it's a fairly simple process to respond to a motion to dismiss like that. Then the only question was the legal question of, is the president immune from criminal prosecution? And Trump's lawyers said he was, because everything he did, talking to the vice president, talking to the state officials, talking to the public, and the crowds on January 6th, those were all official acts of the president, and official acts of the president are immune from the criminal law. Now, what's the basis for that? Nothing in the Constitution. He said, well, it's implicit in the Constitution. And so the district court heard that argument and said, you're wrong, Mr. President. There is no immunity in the Constitution. And so he appealed to the Court of Appeals, and the Court of Appeals agreed with the district court. They've looked at the case, they've looked at it all, and heard all the arguments, and decided, well, I don't think there's any immunity there at all. There might be some defenses, and there might be some regulations, and there might be some variations here and there that would affect it, but there was no blanket immunity. And so Trump then appeals to the Supreme Court, and the Supreme Court reverses both of those two lower courts and says, yes, there is an immunity to some degree. And so our job is to figure out what the court said and what, to the extent there is that kind of a judgment. Now, what I'm going to suggest to you here is that we look through this diagram that I've presented and see if we can get a sense, at least my sense, of what the opinion says. The opinion is not particularly clear, and some of these categories are not exactly exclusive of others, and so it's not a tidy sort of scientific kind of thing, but it's as close as I can read this opinion, and I've read it a number of times. We need to kind of think about it. So the first question, if you have the president alleged to have engaged in something called a violation of the law, first thing you have to figure out is whether you're talking about civil law or criminal law. And some of the cases against presidents have been civil cases. That is, an individual would sue the president asking for damages. Somebody sued President Nixon and said, when your latest order with respect to the Veterans Department or whatever it was, I lost my job and that was illegal, and I want damages. So that was a civil case, and you know it's a civil case because the complaining party, the plaintiff, is a private individual, and he's suing the official. And the remedy asked is for damages, and that's a civil world. And in the civil case, the court wasn't particularly troubled about that. First, they have to decide between, was it an official act that you're complaining about, his firing of you, or was it a private act? And if it was an official act, there's no question about the fact that the president is immune from any civil action growing out of conduct which is official. And by immune, we mean without qualification, no matter what harm that kind of holding might be. That's all, doesn't make a difference. We have to protect the president from civil actions for damages, no matter how bad a guy he was, no matter what his motive was, no matter whatever. He is just immune. We can't ever allow people to sue the president for damages for conduct which you classified as official. On the other hand, if it's not official conduct, if it's private in some sense, then the president is subjected to liability for damages just like anybody else. So with respect to the civil side, it was relatively well settled. A couple of cases came up. Paula Jones had a case against Bill Clinton, and that was thought to be what he was charged with doing was not official by any means, even for him. And so that case never came to trial, but she got a massive settlement out of it because there was a chance that he would be liable for damages. The case could not be dismissed on the grounds of immunity. So with respect to the Air Force guy who sued Nixon and Paula Jones who sued Clinton, it was reasonably well understood that if you're talking about civil liability, if it's official, the president cannot be sued. If it's unofficial, the president can be sued. Okay, now when you move over to the other side, President Trump claimed that same rules ought to apply. If it's official, it ought to be immune, and if it's not official, it ought not to be immune. The same rules you'd apply in a civil case. And so the court agreed with half of that. They said, well, if the act is not an official act, then the president is not immune from criminal prosecution. And then the president said, well, then can we just go ahead and have the same view we have on civil cases, which is that official acts ought to also ought to be immune. And the court said, well, not quite. There's not quite that much immunity in the criminal case. Now you might say, why would the court be more generous to the president or to the plaintiff in a criminal case than the court is generous to a plaintiff in a civil case? You'd think that the criminal case would be much harder on everybody. And the answer has to do, I think, it's a practical answer as far as we can figure out. A civil case is easy and cheap to bring. You all can file a suit against the president tomorrow for a couple of $100, period. And then it'll be you against President so-and-so. And if you permitted that kind of case, you'd have millions and millions of lawsuits filed against the president. And the president would occupy all his time and thought worrying about all this litigation. Many, many fewer cases involved on the criminal side because, as I've said, to get a criminal indictment, you have to have a special prosecutor who does an enormous amount of research and then present that to a grand jury and get the agreement of the grand jury unanimously that the guy probably did this and these laws probably prohibit it. So there would be many, many fewer cases. So we're not quite so needful of immunity in the criminal side. Now, some of you may think that's backwards, and some others have thought that backwards, but that's kind of the rationales. So we get with respect to the criminal side of this, if the conduct that the president is charged with is criminal conduct, if he's charged under a criminal statute, then it's not automatically. So what the court does then is to divide the official acts up into two kinds. And one of them is called core functions, and one of them is called non-core functions. And with respect to the core functions, you get the same answer you get on the civil side, that official acts having to do with conduct that are involved in core functions, that those are going to be immune. You can never prosecute a president for doing that. Well, we'll have to talk about what core functions are and how you distinguish them from non-core. But with respect to non-core, then you're into an area that is called presumptive immunity. And it turns out that what that means is that there is an immunity unless the government can prove that going on with this case, this prosecution, will not really interfere with the executive function. If the government can prove that, then there's no immunity and the president can be subjected to criminal prosecution. But if the government cannot carry the burden of proving that this prosecution will have no effect on the executive branch, no significant effect, then we have to regard that as immune. Now, if you look at this chart, you'll see that on the criminal side, if it's not official conduct, then it's clear that there's no immunity and the president's liable or subject to prosecution. If it's official, then you have to decide how official it is. Some official acts are so close to the core of what the president does that they're going to be protected by a complete immunity. On the other hand, if they're less close to the core in that, then the president will be protected from dealing with those unless the government can prove that there's no effect on the executive function. Now that's the Roberts opinion as I read it, and a lot of other people have read it. And the difficulty, of course, is there are a lot of unanswered questions. How do you distinguish official acts from unofficial acts? Well, if you look at the case, the kind of acts that Trump was doing, they involved discussions with the Department of Justice, they involved discussions with state election officials, they involved pressure on the vice president to do something, they involved angering a crowd that went on to attack the Capitol. Which of those things was official and which was not? If they're unofficial acts, then there's no immunity, and the president is subject to criminal punishment. On the other hand, if they're official acts, so how do you tell the difference? Well, the Roberts opinion is not terribly clear. One of the basic ideas, I think, The court says if something is authorized, the president is doing something which is authorized, then it's probably an official act. So if he does something that's authorized by an act of Congress, then it's an official act and there's no chance of prosecuting him for that. He is immune. On the other hand, if it's not authorized, if he does something that's not authorized, then the opposite result. That's a hard notion to handle because he does a lot of things that you can't find any specific authorization of. If he's speeding, for example, and gets stopped by a policeman on his horse or whatever he's using, is that an official act? Well, doesn't sound official, does it? Until the president says, well, I was on my way to a NATO meeting. Well, this president wouldn't go to a NATO meeting, but I was on my way to a big international meeting and I was late and I had to get there and I had to speed. Well, does that make speeding an official act? I think you can see the difficulty of drawing that line. And so how does Justice Roberts draw the line? Well, he doesn't. He says, well, sometimes I know that when the president is doing something and only the president can do it, then it's probably official. For example, and this is one example he gives in the case, when the president talks to the attorney general and says, do something like this, well, that has to be an official act because part of his duty is to regulate and manage and direct the Department of Justice. And so he's got to be able to do that. And the result then is that if part of the complaint against him in this case is that he pressured the attorney general to do something, there has to be immunity there because that clearly is an official act. But the court then says, but he may not always act as the president. He might, for example, be acting as a candidate for office. That's still the same guy, but now the act is different, and that might not be official. Or he might be acting to do something else that the fact that he is an official isn't enough to make it an official act. So, and with the case we're all waiting for him to use as an example, but he doesn't, is suppose he makes a speech on January 6th to an angry crowd. Is that an official act or is that an unofficial act? And Roberts says, well, ordinarily when the president talks to the people, that's official. He's supposed to do that. On the other hand, if he's talking not as a president but as a candidate, then maybe not. And we just don't know. We don't have enough facts. This case is handled on a motion to dismiss. There's never been a trial. So we're going to have to send it back to the lower courts to have them look more carefully at the specific facts involved and try and figure out whether or not that act, that speech, was official or not. Okay, well that's about all we get about what an official act is. With respect to his talks to the vice president, he has authority over the vice president and has to talk to him. So the court says that probably is an official act, but it may not be official enough to grant a complete waiver, a complete immunity. So we better send that back and have them look, because the next category here is the question of core functions and non-core functions. And again, there are very few examples, and the only ones he gives in helping us figure out what this distinction means. He talks about some things that the Constitution specifically gives to the president and makes it clear in the text that the president alone can do this. For example, the president can pardon a criminal. Well, Congress cannot do that. Nor can Congress interfere with the president's doing that. So Congress can't make it a crime for the president to pardon somebody, no matter what the basis for the pardon is. So the court says that's a core function. And the other ones mentioned, the other examples mentioned are recognizing a foreign government. The Constitution says the president can do that, and Congress cannot interfere with his doing that, and therefore that's a core function. Appointment of high officials. The Constitution authorizes the president to do that. Does not authorize Congress to interfere with that in any way, so that's another core function. And with respect to core functions, then, as the chart shows, the president cannot be prosecuted for that, no matter what he does. So then what are the other functions? Well, they all have to be, as you can see from the chart, they have to be official matters, or they wouldn't be at this place in the chart. But they're not quite as official as the core functions. They're not specifically identified in the Constitution, or specifically identified in a way that makes the it into the core category. And the language the court uses here, and it takes it from an earlier case, but if the conduct is preclusive, that is, nobody else can do it, then it might be a core function. And if it is not, if several people can do it, if they share the power to do it, then it's an other function. Still an official function, but not entitled to blanket immunity. The only immunity in these other categories is, as we say, presumptive immunity, which the court always says at least presumptive immunity, which means after this case comes back from the Court of Appeals, the Supreme Court might decide that some of these presumptive immunities are also absolute immunities, but it doesn't say that there. It just says, with respect to things that are not in the core, official actions are presumptively immune, and that means you can't prosecute the president unless the government can show no significant effect on the executive branch. And I think if you look at that question, how do you tell what's a significant effect? The court doesn't tell us very much. The language used, I've got a quote here someplace if I can find it. It says, see what you make of this sort of language. The president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that fact would pose no danger of intrusion on the authority and functions of the executive branch. And that's basically all we get. And so my summary of it here is significant effect on the executive branch, and that's kind of all we get out of the opinion. It doesn't tell you very much, because nobody knows how significant something has to be in that category. So, but the point you look at there is, what is the effect of this prosecution? And not just the prosecution, what's that effect on the executive branch, but what about the fear of prosecution? As we said before, we don't want the president saying, well, A is the right thing to do, but if I do A, I might get put in jail after I'm out of office, and so I'm not going to do A, even though it's the right thing to do. And the court didn't want the president to be in that situation. They want a vigorous, energetic executive. So let's take away that problem. If the fear of prosecution is enough to make the president less vigorous, then he ought to be immune. He ought not to have to work with that fear. Well, we could go on with this for days, but this is as clear as I can get of what the opinion said. Now, the dissent, Justice Sotomayor's dissent, is passionate. She thinks there is no immunity for the president in the Constitution, and for that reason, this is all made up by Justice Roberts and his colleagues. And she's so distressed about it because it violates this principle we all respond to: the king, our king, is never above the law. And she just doesn't find any constitutional warrant for that decision. And there are lots of ways the criminal process can be used to adapt and adjust to a prosecution against a president, if there are some reasons for that in terms of timing or whatever. But immunity is just the wrong answer, in her view. Usually, dissenting judges, at the end of their opinion, write, respectfully, Justice Sotomayor. But in this one, she wrote, fearing for the future of democracy, I dissent. So clearly, she was really upset by this, as were her colleagues. That's basically what the case says. And as I say, I can't be clearer on what the distinctions are between these three categories on these three questions. That's kind of where we are. Well, let me just ask then, what does this change? Well, it changes a lot, it seems to me, because now a president has a different set of calculations than he or she used to have. It's possible that the change will not be very great. One of the things one hopes for is that we don't have very many presidents in the future who are guilty of criminal violations. And if all the presidents we have from here on out don't violate criminal laws, then we're okay. We don't need to worry about this immunity. And I hope that that's where we're headed, if we can get out of this current nightmare. But we don't know. So if future presidents avoid criminal actions, then, trying to upset the government, trying to destroy the electoral process, whatever. If presidents avoid that in the future, then we don't have to worry about this case. It'll be ranked with General Grant's case from 1870. And that didn't get to the court instantly. But on the other hand, if the court uses this window to alter the structure of our government, for example, if look at this first category, distinction between official and non-official. If the court says, well, everything the president does is official, well, that sort of rules out the other category. So if everything the president does, speech making or whatever, is regarded as official, then you've got a very wide immunity. Similarly with the core functions thing. If only a couple things are core, you've got one result. And if everything is regarded as being in the core category, you have a different result. Or on the third issue, if the court is never persuaded that there will be an effect on the executive branch, or there will always be an effect on the executive branch, you'll have different outcomes. So what I'm suggesting is that a lot depends on how these terms are used. They're very vague, and the language and the opinions not very helpful in working them out. So there may be some significant change that this affects, and I'm hoping that we don't have to worry about that very much, because I'm hoping we'll have a better idea, better luck with presidents than we've had in the past in this particular case, and just get presidents who regard complying with the criminal laws as being part of the oath that they take. The critics of the case point out something that might not be apparent to you, and that is that mostly this court has taken the view, as we suggested earlier, that they're textualists, they're originalists, they're literalists. And you don't make an argument successfully to this court that, well, yes, that's what the Constitution says, but it's a terribly bad idea. The court says, we're not in the business of just avoiding terribly bad ideas. Our job is to apply the text as it's written. And what does that mean? Well, we'll look at the text, we'll look at what the framers said about the text, we'll look at earlier cases that have interpreted the text, we'll look at the structural impacts of the interpretation, and we don't care about whether it's a good idea or not. That's not our department. Our job is to apply the document as it's written. Well, here, the court rejects all of those things. The text here seems to run the other way. The text does not confer any immunity on anybody. And even what text there is cuts the other way. There is some text in the Constitution about immunities for legislators, for some of the things they say in the halls of the legislature. Clear immunity. So the drafters knew how to write immunities, but they didn't. They included one for legislators. They did not include one for the president. So the text would suggest that they left it out intentionally. Similarly with the opinions, the Supreme Court opinions, there's no one on point, but all we've seen in the past have been cases that are inconsistent with the idea of there being an immunity. For example, why would Nixon need a pardon if presidents were immune from criminal prosecution? So the cases, they don't rule on this issue directly. The implication of most of these cases is that there is no presidential immunity. And structurally, this case means that the court now, because these terms are so vague and the court has such discretion in how they're to be interpreted, the court has enormous power over the legislature and over the president. That is to say, the balance of power between the branches is altered. And that's something that usually this court doesn't like. So the usual practices of this court in interpreting the Constitution, the text, the statement of the framers, the recent cases, and structural implications, which the court always relies on, they reject all of those in this case. So a lot of critics have thought this is really a bad case. So what do we do if we get a president who violates the criminal law? Well, there are a couple of options. One, of course, is impeachment. We can impeach a president, and we can't seem to get a conviction in the case of Clinton or Trump. Tried twice with Trump, impeached both of them, but couldn't get a conviction in the Senate. So we've got a polarized country, and the branches of government are divided that way. And impeachment, which comes from the House, is possible, but if the other party is in control of the Senate, there won't be a conviction. So impeachment, the way things are set up these days, is not a very realistic remedy. What about elections? Let's just elect better presidents. That's an option. If we get a president who violates the criminal law, let's not worry about prosecuting him. We don't care about that. Let's just be sure he doesn't come back in office. That is an option, but as you know, that's also a difficult thing to do, as we're about to find out next week. There's the 25th Amendment, which allows members of the cabinet, when the conditions are met, to replace the president, and that's another possibility, but it doesn't seem like that's likely to happen. And we can amend the Constitution, of course, and put an immunity in there or take an immunity out. But amending our Constitution is almost impossible. It was designed that way, and you're just never going to get the kind of proportions you need these days to amend the Constitution. There's a statute been introduced already called the No Kings Act. And this sort of says the president has no immunity, and if anybody disagrees with this statute and thinks it's unconstitutional, they cannot bring it to the Supreme Court. And the authors say, Congress can declare what the jurisdiction of the Supreme Court is. And we're saying in this statute that you can't hear this case, which is kind of intriguing, and I don't know if it could get to the court, what the court would say about it. But there are some options: impeachment, elections, 25th Amendment, statutes, constitutional amendments. None of them are going to happen soon. None of them probably were going to happen I used to say things like in our lifetime, but like every year goes by, I have to find another way to talk about that. But soon, I say. Okay, now, with all of this stuff in your mind, I expect there'll be a test, right? I expect you'll understand all this. But if this is more than your brain can hold right now, and I can appreciate that, let me give you a couple of takeaways. It seems to me what the court has done is say that that when you come to the question of is the president above the law, is there an immunity from criminal prosecution? I think there are three categories of conduct that have to be talked about. One is official conduct, core conduct which seems to be directly the result of constitutional authority. And with respect to that kind of activity, the president will be categorically and completely immune. You cannot bring a criminal action against the president for one of those things. The second category is things that are, we would call official conduct, but not quite in that first category. And with respect to those, there's some kind of something we call presumptive immunity. That is, there is no immunity, or there is immunity unless the government can prove that it'll cause difficulty in operating the executive branch. And the third category is conduct which is not official. It's private, personal, has nothing to do with the government. And with respect to that, there's no immunity at all. You can always claim that you can always prosecute the president for conduct of that sort. So we can just think about those three categories. Strongly constitutionally authorized, complete immunity, not quite so strongly, but still official, partial immunity in the presumptive immunity category, and personal or not official stuff, for which there's no immunity at all. And I think if you keep those things in mind, that'll be a reasonably accurate summary of all this other stuff. Okay, now, questions, and I've used up most of the time, but I'm happy to answer questions. Are there mics around, Risa? Okay. If you raise your hands and wait for a mic, why, you can ask me a question. I'll see if I can dodge it.
If it's considered that the president's conversation with the vice president is a core function, but if the conversation is to induce the vice president to commit an illegal act, is Roberts saying that's a core function?
I think, I don't know. I have to start off with that. I'll start off all my answers that way. My guess is, he says that the president does have authority to talk to and manage and direct the vice president. So that is a very official act. My guess is that would be either complete immunity or presumptive immunity in which the presumption can't be overcome. It'll come out the same way. I think you will not be able to prosecute the president for discussions with the vice president. That would be my guess.
Hi. I'm wondering about bribery. It seems to me that Trump has certainly conducted himself in a way that indicates there's some very close to bribery equivalents that he's already committed, and he's currently apparently making promises to donors, corporate donors, to act on their behalf. These may not be complete briberies yet, but what would you say about that?
Well, I don't know, Connie. You're talking about, I guess you're not talking about Musk, but he comes to mind. It seems to me somewhere buried in the Roberts opinion is the notion that motives cannot be examined. That's you ask if the act is official, the act is a core act. You don't ask what the motive was. And if he means that, then the president who takes the core act, say, and appoints somebody ambassador to Australia, because the ambassador, the person gave him a huge bribe. It seems to me if you can't talk about motive, you just ask whether appointing ambassadors is a core function, and if it is, there's no liability. But that's a tough case. The tough case that came up in oral argument, you may have read about this, the cases where a justice would say to one of Trump's lawyers, do you mean to tell me that if the president authorizes SEAL Team 6, the group that took out Osama bin Laden, and asks them to annihilate one of the president's political rivals, that would not be actionable? And there wasn't really a very decisive answer to that question. So the critics of the case think that there's so much fuzz in these standards, these groupings, that the president will be able to do, or the court will be able to do whatever it wants. And in the music business, we talk about words and music. And now and then when I'm looking at one of these cases, I see the words, but I can hear the music. And the music in this court is very much in favor of a strong, independent president. And if with that music playing, something like a bribery case might be dismissed. And now we don't know the answer of what if the president could order an assassination of a political rival, but technically, if what he's doing is talking to another government official that he's authorized to direct, that should be immune. Nobody thinks he should be, but that's I think where the logic goes. Question? Yes.
Bill, under the whole issue of election interference, the president is recorded as having asked the Secretary of State in Georgia to find 11,000 plus votes. Mm-hmm. Wouldn't that fall under the category you've identified as not official? Because the president has no role in the way that any state, but in this case the state of Georgia, selects its electors to go to the college to vote for the president. So I don't, would that be considered an official act or not?
By me, it would not be an official act. But the court said in this case was, cases like that are so fact-specific that you need to know exactly who said what, when, what the climate was, what they really meant, and what else was going on. And we at the Supreme Court don't have evidence about that, so we're going to remand it to the lower court to sort that out. And most of these cases, when you get to the edge, that's the answer Roberts gives. We don't know the answer to that question. We need more facts. We'll send it back down to the lower court to figure it out. So we don't know. I share your view. If I were in the lower court, that's what I'd do. But keep in mind, the Supreme Court has reversed that lower court several times in this case already. So again, if you listen to the music, if I were a lower court judge, I'd say, be very careful. I'll get reversed. So, but I very much agree with your thoughts.
Doesn't the Constitution guarantee a...
Excuse me, let's get one question at a time. Who's got the mic?
So who's up? Okay.
Okay.
Doesn't the Constitution guarantee a speedy trial? So how long can Trump drag this process out through the appeals process? Could that go on for years?
I think it could. I think it could go on because there are important values in timing of judicial proceedings. And particularly in criminal cases, the courts are usually pretty generous with defendants when they say, well, we can't file this pleading today, we need a couple more weeks. There's something has come up or new witnesses appeared or something has happened. And the courts are very reluctant to force things into trial before they're ready. So the courts are pretty generous with that. Now this case, and you know, every conceivable problem has arisen. This case in Georgia, for example, the fact that the district attorney had a romantic relationship with one of the prosecuting attorneys, who knew that was going to come up? And what does that mean? Well, it has to be delayed, there has to be investigation, you have to look at it and figure it out. So there are all kinds of things. My guess is the Trump strategy from the beginning in all of these cases has been to delay, delay, delay. He wanted nothing to happen before the election. And speaking of the election, if Trump loses next week or whenever the election is, a lot of these things are going to play out. It may be that people will just forget it then. He's gone, that's good riddance. If he wins, he will appoint the next Attorney General who will run the Department of Justice. And in theory, he could just say to his Attorney General, don't bring any more cases of that kind against me. And that would be the end of it. So it's a possibility. Or if he does get convicted, he can always pardon himself, I guess. But some of these cases are state cases, and you can't do that in state cases. But I think nobody quite knows what's going to happen. If he wins, he has a very strong hand in the outcome of all these cases. If he loses, heaven knows where the rest of us are, depending on what turmoil follows that outcome. Yeah.
At the beginning of your talk, you pointed out that criminal prosecutions of presidents or ex-presidents are very rare and haven't been the way that... is that better?
That's better.
Okay. I say that the Grant case illustrated that prosecutions of presidents or former presidents are rare, but the political discussions of this opinion have frequently given the impression that there'll be no checks, no judicial checks on a president, and there's been no discussion of the primary way that the executive branch has been restrained by the court, which is through injunctions. Are you at all disturbed about how, in the public discussion of this case, and I appreciate your very nice description of it, it hasn't been put in the context of the ways in which the judicial branch actually has protected the public, including the last Trump administration, from illegal activities.
Yeah, the framers gave us a system in which the branches were supposed to attack each other and keep each branch in its particular area. And that's why the president can do something, but Congress has to agree, and so on. And when the executive does something that Congress didn't want, the court can set it aside. So you're right, that these checks and balances that we learned about in high school are real. And one of them is that the court has to take a real attitude about its responsibility to keep any of the other branches from aggrandizing itself by expanding its powers beyond what's consistent with the Constitution. But those are all questions of degree, and I think this court is, as I say, very strongly in favor of a strong president with limited controls by Congress. And so with that attitude, and there's a school of thought that it's called the imperial presidency, or it has various names, but there's a school of thought among a lot of people that that's a good idea, that the president ought to be strong, because Congress can't get anything done and the courts don't do anything anyway except advise opinions. And the only place you can get anything to happen is in the president. The president shouldn't have his hands tied. So that, if you feel that very, very much, then it'd be less likely that you're going to allow a limit on the court. And so I think it's just the feature of our times. A lot of us think that the president ought to be subjected to control by Congress, and but at the margins where these cases all come up, small variations in phrasing and so on matter. And I think the current court seems anxious to protect the president, the office of the president. They never say anything about the president's personal. He's not a person, it's an office they're protecting. And if you read the opinions, they all take that high road. We're not talking about any particular person. We're talking about the office, and the office needs to be free from worry about possible prosecution. Notice, incidentally, that it might be useful to think about different time periods. When Paula Jones sued Bill Clinton, the offense she was complaining about was not done by the President of the United States. It was before he got to be President of the United States. He was the governor of Arkansas. So the conduct occurred before he was in the White House. And with respect to some of the other cases that have come up, sometimes the conduct occurs during the office. Sometimes it occurs after the office. Trump's conduct was he was President of the United States when he did all this. He'd been unelected, we think, but that happened during his time. But the prosecution happens after he's out of office. So you're careful about the timing there. Nobody likes the idea of a criminal case or even a civil case against a sitting president. But if it's an unofficial act, as it was in the Paula Jones case, the court went ahead with that even though the president was sitting at the time, and even though the conduct that she was complaining about had happened before he got to be president. So there's another layer of complexities there in the timing questions. I should let you go. Yes.
Bill,
Yeah.
do you feel that Jack Smith's revision of his indictments will clarify or meet some of this opinion?
I don't know. After the Supreme Court opinion came down, you may know Jack Smith filed another document adding more evidence in support of his view that the president had violated criminal laws. And that document, 150, 60 pages long. These people don't operate in short documents. And if you look through it, you'll see all kinds of new things that the president said, things the president did. But one of the things he took out of his indictment charge was the notion that there was a criminal violation for the president to have put pressure on the Department of Justice to do some sham investigations. Because the court, in its opinion, said the president discussing things with the Attorney General, that's a core function, and that's immune. So I think Jack Smith read that and went back and took that information out of his original document. But he added a lot more. So I don't know. And we haven't seen any of this stuff yet. It's never been presented in a trial. We never got all the witnesses and examination and cross-examination. None of that's happened yet. We're talking about documents, and so we're not quite sure. But yes, I think he did read the opinion in this case, Smith did, and he did modify his indictment by taking out those things the court said were immune, but he left a lot of other stuff in that are not, that could be unofficial acts. One more question. I think we better let people go. Yes.